Hi, sorry there. My name is Dr. Cora Stack, and I'm asking for your support to help me fund an important legal case currently before the Irish courts. And the case is not about a personal grievance, it's a constitutional challenge. I'm asking the courts to examine three things that go to the heart of democracy and the rule of law in Ireland. First, I'm doing this now to try and sort of break it down as you would, a lecture. Break it down, keep breaking it down so that the ordinary person understands what's going on here. Because often, people don't, because of this lack of like breaking it down and understanding that I have to do it to try and understand. I have to break things down and break things down myself in order to, and see now what I've discovered by my breaking things down, with powers. First, the Fine Gael Leadership Directive, often referred to as the block, and whether it's compatible with the Constitution and the separation of powers. Now, I've looked at Articles 12 and 1 and 6, and there's a number of other articles, 28, and different articles, and kind of I've written a paper kind of surrounding the block by all of those, and done a statistical analysis, and beyond the probability of reasonable doubt, there is a constitutional breach. So I mean that was one of our key points, but it wasn't. I didn't use the statistical analysis there. So that's one of the key points. So second, the current design of Ireland's protective disclosures regime. This is very tricky now, as amended, which appears to be out of compliance with the EU Whistleblower Directive. That's 1937, 1937, yeah, and the EU Charter. And third, and this is crucial, this is where I think is absolutely critical. This particular point here is something I've just observed looking at a number of recent cases, and that's a pattern I've identified through multiple cases in Ireland, and then looking internationally. Now, sometimes when you're examining the international picture, you get a distinctly different pattern. You might get a similar pattern in a number of countries, and then another similar pattern in a different set of countries. But this was the same pattern in a lot of Western democracies. So it was the identical patterns and the identical wordings used. It was like a toolkit used with these same words for what I'm going to say. So the pattern was pretty much the same here, rather than in some countries this and in some countries that. So right across the US, Canada, and in the pattern emerges, and the wording was almost identical. So this is what I've observed, but I wouldn't have done this only that 4 cases have come through the courts recently, consecutively over a short period, where you just looking at them, you could see there was a very striking similarities or patterns, and then looking at abroad, then you get you can see that definitely your pattern is it's very clear what's going on here, or what appears to be going on. So genuine constitutional cases are increasingly, over many years, being reframed or reclassified as political or personal grievances. Things like the standing, your standings being questioned, all this sort of technical language. When this happens, the cases are quietly removed from serious constitutional scrutiny. So they're kind of shut out of the courts. You're brought in, and then the case that you thought you were bringing gets turned in, or reframed, transformed, put to a box, transformed, reclassified, reframed, and then on the basis of the reframed case, you get a judgment which was nothing at all to do with what you put in originally into the box. So the question is, that's what seems to be happening, and I'm calling that reframed or reclassified. This allows systemic issues, so this is not just unique to Ireland, but happens in many constitutional cases where the consequences could be embarrassing for those that are being scrutinised. This allows systemic issues to go unexamined, not because they lack merit, but because of how they are categorised or classified. It's not unique to Ireland. It's a global pattern, of perhaps increasing deference to the executive. Perhaps this is what's going on. So there's no. This is just a pattern and it is not in the interest of democracy or the people that are in that democracy. In my opinion, clearly, it's not in the interest of democracy. But Ireland now has an opportunity to lead. Now, I would have never spotted these patterns, only that there were 4 cases in the courts in the recent number of adjudications in a number of weeks. So otherwise, if it was only one, you'd need a few to see, was there a pattern? Then you have to look abroad to see, is it the same? Is it the same or similar? It might be or it might be. You just have to look at what the evidence says. I'm asking the Irish courts to help reverse this trend, to reaffirm the separation of powers and to ensure that constitutional and EU law issues are heard properly, not filtered out through procedure, reclassification or reframing or recategorisation. If successful, this case could send a very powerful message that Ireland is listening, which is very important, given what happened in the recent presidential nomination, not in the presidential. So many people stayed at home or voters spoiled their vote, and I think that they felt that Ireland is not listening. So let's try and change, and hopefully the courts will now listen, and that there are a lot of people that are saying that Ireland is not listening. So everybody can change. The constitutional accountability still matters, and that other democracies may follow. Legal cases of this nature are extremely costly, and I cannot do this alone. In fact, I feel that going in without equality of arms, that is, without a corresponding legal team to, a legal team representing the state, I think that in itself shouldn't be allowed. And you're going in almost immediately, you're going into a case where there isn't equality of arms or equality before the law, and yet you're expected to have standards. And then when things are reframed or reclassified, it even furthers the injury, or, and only that I spotted it, it makes the injury worse. But it's not just to, I thought it was just to lay litigants that this is done to. No, it isn't. It seems to be, done to anybody taking on the state, where the implication of the state may be considered embarrassing. But we've got to deal with this. I mean, and if courts don't stop this, democracy will erode, and it is doing this already. So it's time now for the courts to stand up to this. To stop doing this reframing and to face up to whatever mistakes are made by government, so that there are other ways. For example, I think there was a recent case about the super junior ministers and other issues, and I think people were talking about that they had to do things to get around, inverted commas, the Constitution. Well, perhaps the Constitution needs to be amended every few years for housekeeping issues. That there needs to be some regular. It doesn't have to be the Maastricht Treaty